Hello viewers. In lecture 9, I have told you about consideration and the limitations prescribed under section 23 of the Contract Act, by which the consideration becomes unlawful. The last limitation is the court regards it as immoral or opposed to public policy. Pausing here for a moment. What does these two words mean? Immoral, public policy. The epithet, the adjective immoral, is very wide and could be applied to any human conduct. If it is so, any consideration could be held to be unlawful on the ground of it being immoral. Similar is the situation with the phrase public policy. It's a very wide word. And in fact, courts have held that public policy is like an unruly horse, and you can obviously visualize that you never know where the unruly horse would lead you. And therefore, so far as we are concerned, the meaning of both these words is restricted so far as the word immoral is concerned. Essentially, courts have restricted it to the sexual immorality, like illegal cohabitation, rent for running brothel activities, paying money for obtaining divorce, for getting married to that person. These are all sexual immoralities. And courts have restricted the meaning of the word immorality to only these aspects. So it's not all immoral conduct which may be regarded as such in ordinary course of life. Not all acts which are otherwise not punishable may be treated as immoral and then declare it as unlawful. No. The meaning of the word immoral is restricted to sexual immorality and any transaction for which consideration or object is sexual immorality, it would be unlawful. Similar is the situation with public policy. In fact, courts have held that it is unsafe to expand the scope of public policy, because the result would be the same like immorality. And therefore, in fact, courts are prevented from inventing new areas of public policy. Because public policy, like again immorality, would be in any part of our life. Every statute has a policy, but that does not necessarily become a public policy. And if it is so widened, then what will happen? Very loosely, the consideration or object could be held to be unlawful and transaction would be void. Therefore, like the first one, here also courts have said that public policy is not to be enlarged and is restricted to certain areas, which of course I will tell you today. And they are more like trading with the enemies, stifling the prosecution, like that. I'll first tell you about trading with the enemy. The words themselves are clear enough, not needing any explanation. If you are trading with an enemy country, obviously it can never be tolerated, and therefore the transaction would be, consideration would be, object would be unlawful so far as Indian law is concerned, and therefore any trading with enemy, yes, it is unlawful. How long? The answer is till the end of hostilities. No time is prescribed for this. There must be end of hostilities. The second ground of public policy is stifling prosecution. Friends, Section 28 of the Contract Act, which deals with restraint in matters of legal proceedings, is a bit different than this. I'll just give you one example of a criminal offense. In India, we have a separate category: compoundable offense and non-compoundable offense. Non-compoundable offense cannot be compromised. The provision in criminal law is prosecution cannot be withdrawn. It has to come to its logical end by trial or by pleading guilty or as provided in the Criminal Procedure Code. Now the situation is that you want to somehow baffle the prosecution, and you bring a situation that ultimately the prosecution has to be resulted into acquittal, either by making some arrangements for tampering evidence, witnesses, or creating any circumstance by which the prosecution is stifled. Public policy demands that no, you cannot do it. And therefore, any consideration, any object for this part would be unlawful. Similar is the situation about champerty and maintenance. First, I will tell you here what is champerty and what is maintenance. Champerty is sharing the fruits of the litigation, the bargain in the gains of litigation. It is most prevalent in USA. In fact, practically all throughout the world, it is the only country which has commercialized the legal and medical profession. Elsewhere, sharing with the fruits of litigation is prohibited. And obviously litigation is not for profit. It is for doing justice. Maintenance is helping the person to maintain, to carry on the litigation in which you have no interest. The legal philosophy, obviously, if you have no interest in litigation, why should you encourage it? So, champerty and maintenance, they have been since beginning regarded as an interference in the course of justice. And therefore, as a matter of public policy, if the consideration or object is such which would be in the nature of champerty or maintenance, it would be unlawful. Similarly, the next aspect is the interference with the course of justice. There are a variety of ways in which you can interfere in the course of justice, in the administration of justice. The simplest example is to bribe the judge, would be interference in the course of administration of justice. Law regards obviously the same as unlawful, and therefore it will be hit on the ground of opposed to public policy. Even influencing the judge without bribing, yes, would be an interference in the course of administration of justice. Similarly, next criteria is marriage brokerage contracts. Procuring marriage. Again, this is different than section 26 of the Contract Act, where agreement in restraint of marriage are declared void. We will take it separately. Say you give money to parents for procuring marriage. Marriage must take place out of free volition of the parties to marriage. You can't make parties to marry for a consideration. And therefore, such transactions are also hit on the ground of opposed to public policy. Next one is agreement tending to create interest against duty. Say the Mamlatdar or the collector or other officer has to perform some duty. You create some interest against that duty. A simple example is giving bribe or offering some temptation. If you decide these ways, your relative would be taken as partner in X firm, which is having huge profits. So creation of interest which is in conflict with the duty. Law says this is also opposed to public policy. The next one is sale of public offices. What could it be? You are well aware with the scam going on in one of the states in the country in matters of recruitment. A number of murders have taken place with regard to that scam inquiry. Selling the public office, raising money for getting appointment on a particular post in public office. Yes, public offices are not for sale. And therefore, if there is any such element, the transaction would be declared unlawful on the ground of it being opposed to public policy. So, essentially, public policy is restricted to the sovereign function and administration of justice and the maintenance of public offices. It's not that each and every policy of the state is a public policy. So far as this ground is concerned, as I have told you, immorality and public policy. For our purposes, the meaning and scope are restricted only to this extent and not beyond. It's not all immoral or all acts regarding public policy would be treated as opposed to it and hence unlawful. Friends, I have earlier made one reference with regard to section 23 that it also covers object, meaning thereby section 23 says consideration and object. Section 10 also speaks of the same. What is this object? The object is the purpose of the contract, the design, and as it is illustrated in section 23 itself. If 2 or 3 parties agree to share the results or fruits or the gains from practicing fraud, obviously this is the object. Committing the fraud is the object. Sharing the fruits of it is the agreement, the consideration. If the object again is hit by any of the limitations prescribed in section 23, it will meet with the same fate. So essentially, consideration not only should satisfy the parameters of section 2D, it also must be lawful as prescribed under section 23. I have already told you earlier that without consideration, the transaction is void. This also has exception. We'll see this in the next lecture. Thank you.